Good morning, everybody. All right, we are back on. Defendants are present, represented by counsel. When we broke last night, we were addressing motions before the court. Probably the most efficient way to go about this is the stated indicated. Want a little bit of time to take a look at the demur on count 7. This is the state of any additional argument after reviewing the demur that had been filed on behalf of Mr. Bryan.
No additional argument. We stand on what we had originally filed and on the court's order on the demur to count 7, which is it tracks the language of the statute and informs the defendants of what they are to defend against, and therefore it is sufficient, and there's no reason to grant the demur to the indictment on count 7.
All right. Go ahead and address that. Then let's get through any additional motions, and I'll start addressing the motions as we go. I probably should have gone around and asked the question that normally leads to some time before the court. Before we get started, anything from the state? From Travis McMichael?
No.
From Greg McMichael?
No, we're ready for our motion.
And from Mr. Bryan?
Yeah, yeah.
Motions then. I'll just go around. Same.
Mr. Hogue is going to speak for both Greg and Travis McMichael.
Your Honor, at this time, on behalf of Greg McMichael, and I will speak for Travis McMichael with permission of co-defendants' counsel, and invite them to add anything you may wish to add that does apply specifically to Travis that I may not mention, but I'm going to try to cover both in this motion for directed verdict of acquittal. And I'll start with the statute that applies to such a motion and then go through the counts in the indictment that I think we have some argument to make regarding it. First, the statute. It's OCGA 1791A, which says, where there is no conflict in the evidence and the evidence introduced with all reasonable deductions and inferences therefrom shall demand a verdict of acquittal or not guilty as to the entire offense or to some particular count of or offense, the court may direct the verdict of acquittal to which the defendant is entitled under the evidence and may allow the trial to proceed only as to the counts or offenses remaining, if any. So I start with count 1, and let me get my indictment up here, which is malice murder. And to make this argument for acquittal on malice murder, allow me to review initially what the elements of that offense are and then talk about the evidence in the case. The statute, of course, is 1651 A and B, and 1651 A says a person commits the offense of murder when he unlawfully and with malice aforethought, either express or implied, causes the death of another human being. So starting with just subsection A, malice, of course, in Georgia law means a specific intent crime as opposed to a general intent crime. And in a specific intent crime, the subjective desire of the defendant is to bring about the exact illegal consequence that his action is intended to produce. So in a malice murder count, that means that that malice means the defendant has the specific intent to commit an act that the cause of which is the death of another person, and that result was the desired result. It was not an unintended consequence, as we'll see is the case with felony murder. So malice, that sort of specific intent, can be shown in two ways by proof, and that's subparagraph B in 1651. And that paragraph indicates two types of proof of this malice, this specific intent. And of course, I always mention that as the definition of malice because it's certainly confusing to jurors, but that's a different issue for later when we talk about charges. But it means no intent, no ill will or hatred, of course, but it's just a specific intent. Two types. Express malice is that deliberate intention unlawfully to take the life of another human being, which is manifested by external circumstances capable of proof. Now, case law indicates that would be things like verbal threats, lying in wait, the kind of circumstances or actions for which the state can produce evidence that says this person had express malice. It's out there in the world for us to see it. We can hear it. We can determine it from the circumstances in which the killing occurred. The other type of malice, much more sticky, is malice shall be implied where no considerable provocation appears and where all the circumstances of the killing show an abandoned and malignant heart. So to further define that type of malice, I need to go to a different place here in my notes to look for a definition of implied malice in our law. What we're looking for is that specific intent to kill where there are no external circumstances capable of proof, but inferences must be made. It's implied. And first of all, you have to find that there's no considerable provocation, which would be, say, voluntary manslaughter, and there's no other justification for it. And then in one of our cases under Georgia law, which is Parker v. State, and I'll get the site here, 270 Georgia 256, a 1988 case. Essentially in Parker, the court tries to define that poetic metaphor we find in the implied malice sentence, which is the abandoned and malignant heart. I find it of interest that there are only 4 states left out of 50 that use that phrase in their definition of murder. Abandoned and malignant heart, having its roots somewhere in the dark recesses of medieval English, but here it is still in Georgia. Idaho, Nevada, and California are the other 3 states that still use that phrase. And so Georgia, in attempting to say what it means, says that it's a reckless disregard for human life. And Justice Hunstein in Parker v. State tries to give some sort of definition for it. It's not a substitute for implied malice. That is, reckless disregard is not a lower mental state or lower standard of proof. It's not equivalent. It's, as she says in this opinion, a special concurring opinion, she says the difference between instructing a jury that a presumption of malice may arise from reckless conduct, and this is for malice murder, and instructing them that reckless conduct and malice are equivalents that can be substituted for one another is not just a matter of mere semantics. A jury is entitled to be instructed how to determine a defendant's state of mind based on the evidence adduced it is not entitled to be instructed that a lesser mental culpability may be substituted for the required higher mental culpability. And then she goes on to criticize the charge given in that case in Parker. But what it comes down to, and it's even cited later in a U.S. Supreme Court case, actually it was a case earlier than Parker, and also an attempt by Justice Brennan to define it. And the case is Arave, I'm sorry, let me start that over. A-R-A-V-E, Arave v. Creech, C-R-E-E-C-H, 507 U.S. 463, a 1993 case. Justice Brennan wrote this: homicides committed without considerable provocation or under circumstances demonstrating an abandoned and malignant heart, a term of art that refers to unintentional homicide committed with extreme recklessness. And then I just use ellipsis there because he goes on to another matter. But the examples given would be, say, somebody shooting a gun into a crowd of people. You aren't intending to kill any specific person, but you certainly know by that reckless act somebody will die. Or driving a car into a crowd at a protest rally. Somebody's going to die. This could be an abandoned and malignant heart. So, that all aside, now the facts of our case, going back to the standard of 1791A, where directed verdicts premised upon no conflict in the evidence, and all reasonable deductions and inferences therefrom. In this case, the state's case in chief, which we've just now heard for the last week and a half, the express malice does not seem to be there. Speaking about Travis McMichael in particular, he's not saying anything or doing anything that could be provable by external circumstances to be express malice. And as we've all seen in the video, the shooting doesn't occur until he and Ahmaud Arbery are locked up in mortal combat, hand to hand, face to face, and in contact with one another, with a gunshot wound that's fatal, that's close contact or near close contact, 1 to 3 inches away. Now, none of that is in dispute. There's no conflict in the evidence there. Obviously, the issue that we expect will go to the jury is whether that was an act of self-defense or whether it's some felony murder, and there are counts in here that address that. There is a pair of counts that talk about using a shotgun as an aggravated assault which results in the death, and that's felony murder. Those are 2 separate counts in this indictment. It's always interesting, too, that malice murder added in the same case with felony murder, while not legally inconsistent, and, you know, of course, George has done away with the concept of legally inconsistent verdicts, is somewhat logically inconsistent. When you ask a jury to consider finding a defendant guilty of malice murder based on proof you think you have, if you're the state, that he specifically intended by his act to cause the death of the person who died, and at the same time argue to them, but hey, also consider that he used a shotgun in an aggravated assault without malice, as the felony murder statute says, and the unintended consequence of that aggravated assault was the death of another person, therefore it's bootstrapped up into felony murder. So that is the argument against count 1 under 1791A as a count that should not be presented to the jury because there is no conflict in the evidence. All of the reasonable deductions and inferences from the evidence do not support a finding by a rational trier of fact that express or implied malice have been exhibited here in the act of shooting Ahmaud Arbery. Now, I can go on to each of the other challenges in turn or stop.
Let's go ahead and get the entire motion out.
The second challenge is to the combination of counts 5 and 9. And let me get my indictment back up. Count 5 charges felony murder premised upon count 9. And of course, we know that felony murder, and I'll get the definition of that, is in 1651C. A person commits the offense of murder when in the commission of a felony, he or she causes the death of another human being irrespective of malice. So we can forget all of what I just said about malice because it doesn't apply here. The state would have to prove the underlying felony and then show a causal connection, proximate cause, between that underlying felony and the unintended death without malice. And in this case, count 9 is the criminal attempt to commit a felony, namely false imprisonment, on, let's see if it says it in here, Burford Drive. Count 9, then, as we know, is the allegation that on Burford Drive, the beginning of the encounter with Ahmaud Arbery, that Travis and Greg McMichael, along with Roddy Bryan, but I'll leave his lawyer to argue his case here, but that Travis and Greg McMichael, using their Ford F-150, attempted to commit the crime of false imprisonment. And then they combined that with count 5 to say that that's a felony murder premised upon that attempted felony on Burford Drive. Well, the causal link between the attempt to falsely imprison someone 3 or 4 minutes before shooting them with a shotgun is just too tenuous to support, under the proximate cause analysis, a felony murder charge in count 5. I'm not saying that count 9 can't stand and be presented to the jury, but when you combine it with count 5 as the underlying felony for felony murder, what we're facing then is a complete lack of a causal link. I mean, you can add several links to get to Holmes Road where the shooting occurs, but there is nothing about the attempt to false imprison Ahmaud Arbery on Burford Drive with a pickup truck, particularly Travis McMichael's Ford F-150, and his ultimate death on Holmes Road. And if you try to do it by party to the crime, 16-220, and connect Travis and Greg McMichael to William Roddy Bryan, as that count does, because it also names him in count 9, names his truck, his Chevy Silverado, in count 9, and then connects them both back to count 5 for felony murder. But 16-220, party to the crime statute, I'll read, it's not long. Every person concerned in the commission of a crime is a party thereto, and may be charged with and convicted of commission of the crime. B, a person is concerned in the commission of the crime only if he, 1, directly commits the crime, and here we're talking about directly commits the crime of criminal attempt to falsely imprison Ahmaud Arbery on Burford Drive, and he didn't, that is, Travis and Greg McMichael, didn't directly commit that crime with a Chevy Silverado. And then 2, intentionally causes some other person to commit the crime. That doesn't apply here. No one's causing anyone else to commit any crimes. 3, intentionally aids or abets in the commission of the crime. That is, proof that Travis and Greg McMichael are intentionally aiding or abetting Roddy Bryan in the commission of the crime of attempting to false imprison Ahmaud Arbery on Burford Drive. And then finally, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. So as the evidence was produced here in this case, Roddy Bryan saw the white truck and saw Ahmaud Arbery, made some driveway assumptions according to Miss Dunikoski, and then went and got in his truck to do what he did. But as we heard, he hollered something that the McMichaels did not hear. The evidence from the state was uncontroverted that whatever he said, there was no indication, no evidence whatsoever that the McMichaels heard it. There was no phone communication of any kind between either McMichael's phones or Roddy Bryan's phones. In short, there was no coordination, there was no participation, no planning, no intentionally aiding and abetting, or intentionally advising, encouraging, and so forth between the 2 McMichaels and Roddy Bryan on Burford Drive, where count 9 concerns my argument here. So the criminal attempt to commit false imprisonment, if that arguably occurred by the McMichaels with their F-150 on Burford Drive, fails to support count 5's felony murder because of the tenuous causal link, approximate causal chain that's just not going to reach. And secondly, if it's a party to the crime theory, there's no evidence at all that there was any participation, intentional, and that's the key word in the party statute, between the McMichaels and Roddy Bryan on Burford Drive. So that's my directed verdict argument to count 5, and I make it in connection with count 9. And yet I am conceding that count 9 could survive a directed verdict and be presented to a jury. There is a conflict in the evidence there about what the McMichaels were doing on Burford. Obviously, we're saying that excuse me, that they're attempting to make a citizen's arrest. The state says they're attempting to do a false imprisonment. That's a legitimate jury issue. But connecting it to count 5 felony murder, that should be directed in favor of the defendants as an acquittal. All right, my third attack here under the motion for directed verdict of acquittal will be the combination of counts 3 and 7. Again, count 3 is a felony murder count, and it refers to the allegation in count 7. And when you go to count 7, the argument there is that the defendants committed an aggravated assault with a Ford F-150 and a Chevy Silverado, which they allege are objects, devices, and instruments which, when used offensively against a person, are likely to result in serious bodily injury, contrary to our laws. But then they connect it to murder in count 3. Again, however the trucks were used in this case by the McMichaels, the trucks were used, yes, to attempt to detain, to block in, to trap Ahmaud Arbery. But again, the argument here will be for the purpose of citizen's arrest, not for the purpose of falsely imprisoning him or assaulting him with a truck. But more than that, that would be a legitimate jury issue in count 7. But in count 3, neither truck was the causal link in the death of Ahmaud Arbery. It was the means by which to get to the place where the death ultimately occurred, of course. It was the conveyance in which the defendants rode. But the truck itself did nothing to cause a serious bodily injury or death, at least the Ford F-150. And this is not alleging in count 7 that Ahmaud Arbery received some injury when he encountered Roddy Bryan's truck on Burford Drive. That's not alleged in this indictment anywhere, even though there's some evidence of contact between him and that truck on Burford Drive. This count is actually not saying anything about that, but connecting it back to count 3, felony murder. So it's the same problem as we just had in counts 5 and 9. It's a failure of a causal link, no proximate cause to show that the truck is connected to the murder in a causative way, and the same with party to the crime. The other thing this combination of counts does, it doesn't say whether this aggravated assault with the truck is occurring on Burford Road or Holmes Drive. We're left to guess which it is. It simply does not specify. Now that's a demur type issue, and that may have been addressed earlier, but here for directed verdict, if the allegation is that the felony murder occurred on Holmes by use of the truck on Holmes, well, the undisputed evidence in the case is while the truck got driven to Holmes Drive, when we see the video, it's undisputed that the truck is parked, the driver is out of it, the truck is not moving, and it bears no connection at all except as a device around which the defendant stood, one Greg McMichael in the back of the truck, Travis out of the truck, and Ahmaud Arbery going around the truck. So the truck is not a causal element in the death of Ahmaud Arbery, and therefore count 3 should be directed as a verdict of acquittal for the defendants. Count 4 and 8 are connected. 4 is felony murder, referring to the allegations in count 8. Count 8 is the false imprisonment allegation, this time on Holmes Drive. And Holmes Drive, of course, is the final place where the events transpired and the tragedy occurred. But this count 8 alleges that on Holmes Drive, using the 2 pickup trucks, the 3 defendants in concert with one another as parties to the crime, falsely imprisoned Ahmaud Arbery, and then the shooting occurs and they make the causal link back to count 4 for the felony murder charge. But again, the evidence in the case was that there was no place on Holmes Drive where the truck was used to block in Ahmaud Arbery. Where the truck is finally parked, as Agent Dial testified yesterday, I believe, under cross-examination with Kevin Goff, he conceded that there were escape routes. There were places Ahmaud Arbery could have chosen to run through yards, across a yard and onto Satilla Drive if he had chosen to. So how one can be falsely imprisoned when the case agent is testifying under oath that he could have kept on running. The truck itself did not impede his decision to turn right and run across this yard onto Satilla Drive and continue down Satilla Drive until he left the neighborhood, or until he encountered the police, which we also have heard with undisputed evidence was on Satilla Drive when the shooting occurred. So he would have run into a police car at the very least, and then possibly Matt Albenzi if that police car was not where the undisputed evidence says it was. So again, count 4 felony murder should fail because it's based on count 8, which count 8, it's fair enough to send to the jury. It's a disputed allegation, but count 4 can't be supported by it. Finally, counts 2 and 6 are connected, and our motion applies to them in this way. Count 2 is a felony murder, this time premised upon count 6, and count 6 is the allegation of aggravated assault with the use of a shotgun, a firearm, a deadly weapon, to wit a 12-gauge shotgun. This one's a little stickier in this regard because the evidence has come out that Travis McMichael pointed his shotgun at Ahmaud Arbery on 2 separate occasions. There's been evidence presented by the state that as Ahmaud Arbery is running towards the back of the pickup truck, on the driver's side of the truck, Travis McMichael raises his shotgun, and then he lowers it and moves to the left front quarter of the truck as Ahmaud Arbery makes a couple of weaving maneuvers and then comes around the right side of the truck, and then the gun is raised again and this time discharged, and those shots are what were fatal to Ahmaud Arbery. The count does not specify here in count 6 which of those 2 gun raisings is the aggravated assault. Certainly the first one, where no discharge occurred, could not therefore have been the cause of death, and it could not support count 2 felony murder since there was no discharge of a deadly shot from the shotgun. And because the count doesn't specify, applying a rule of lenity, this should be read as applying to that, because that by itself could be charged as an aggravated assault. Had the case stopped right there, had Ahmaud Arbery stopped in his tracks, and the state had chosen to say, well, this is no citizen's arrest, this is just a garden variety aggravated assault, you're pointing a shotgun at somebody for no good reason. You didn't discharge it, you didn't kill him, but it still could be charged as an aggravated assault. Well, it certainly couldn't be ever, under those circumstances, the underlying felony for a felony murder if the guy was still alive, if no shot had been fired. So that aggravated assault, though, is still in play. It's been put in evidence. It's not charged in the indictment, or is it? We can't tell from count 6, because count 6 only refers to one act of aggravated assault with a shotgun, and I guess the jury will be left to presume that it's the second pointing that results in the shooting, which results in the death, which results in the felony murder of count 2. Those are my arguments, Your Honor, for a directed verdict on counts 1, 2, 3, 4, and 5.
Thank you, Mr. Hogue. Let's go ahead and address that motion from the state, and then we'll get to Mr. Bryan's motion.
Thank you, Judge. Yes, OCGA 1791 is the statute that governs directed verdicts. And there's also case law out there that, of course, the court is to view all the evidence presented at trial in the light most favorable to a guilty verdict and ask whether any rational trier of fact could have found the defendant guilty beyond a reasonable doubt. So that includes, Judge, not just direct evidence, but circumstantial evidence as well. In this particular case, all the defendants have been charged in this as a party to the crime. And of course, we've got directly committing the crime and then helping, which is intentionally aiding or abetting in the crime. And then we've got intentionally encouraging someone to commit the crimes. So we've got all of that charged together. Looking, of course, at count 1, malice murder, you may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in an instant, and instantly a fatal wound may be inflicted. That, of course, is the current pattern jury charge 2.10.10 on malice murder. In this particular case, there isn't significant provocation. Mr. Arbery ran away from these men for 5 minutes, tried to get away, and was being forced down the street by Mr. Bryan in his dark pickup truck, accelerating towards him. He tries to go around Travis McMichael. Travis McMichael steps out into the street, blocking the street, pointing a shotgun at Mr. Arbery, and Mr. Arbery tries to go around the passenger side of the vehicle. Travis McMichael traps him and tracks him with that shotgun up to the front of the vehicle and basically encounters him right there. He's so close that Mr. Arbery, he passes this. He is so close that when he does this, he's instantly shot. Instantly shot. The video itself speaks for itself. There is that much time, and that shotgun blast goes off, and Mr. Arbery shot point blank. The trajectory was, as you saw from the medical examiner, right here, straight through. That's where the shotgun pellets are. That's where that injury is. So at this point in time, we have met the burden to prove no significant provocation except Mr. Arbery coming around the front. The medical examiner talked about fight or flight. And I understand the defense is going to argue, well, it's the victim's fault. He should have kept running. It's the victim's fault. He shouldn't have been exhausted. It's the victim's fault. He shouldn't have gone to defend himself. It's the victim's fault. He had all kinds of options and alternatives in the face of their 5-minute attack on him, and therefore it's his fault. But that's not what the law is. The law is about the defendants doing a 5-minute attack that eventually resulted in malice murder. How do you see the malice here? Abandoned and malignant heart. You take a shotgun, you point it at somebody, you track them around as they try and run away from you, and when they turn on you, you immediately fire and shoot. The state asks you to deny the directed verdict for malice murder for Travis McMichael and also for Greg McMichael. He is charged as a party to the crime. Greg McMichael had his .357 Magnum on him. He is also yelling at Mr. Arbery. We know that he previously had threatened Mr. Arbery with, "Stop or I'm going to shoot your effing head off." So he'd already told this man, "I'm going to execute you if you don't stop." So at that point in time, we've got Mr. Bryan coming forward. He sees the shotgun. He sees it pointed not only at Mr. Arbery, but it's actually pointed at himself because he's right behind Mr. Arbery. And he doesn't do anything. He doesn't stop. He doesn't slam on the brakes. He doesn't yell, "Oh my God." He doesn't swerve immediately out of the way to get off the road into a ditch to avoid this shotgun. He keeps going. He keeps accelerating. He keeps driving Mr. Arbery toward the man with the shotgun, thus aiding and abetting intentionally Arbery having to run towards a man with a shotgun. Mr. Arbery could not turn around. Mr. Arbery could not run away back because Mr. Bryan is accelerating toward him with his black pickup truck. Therefore, he is also a party to the crime of malice murder because it shows an abandoned and malignant heart on Travis McMichael's part and aiding and abetting in that by both the defendant, Greg McMichael, and Mr. William Bryan. With regard to felony murder specifically, as the court is aware, felony murder must have directly caused the death or played a substantial and necessary part in causing the death. This, of course, is from our new jury charges 2.10.20 on felony murder. And in this case, all 4 of the underlying felonies played a substantial and necessary part in causing the death, because without those 4 felonies, Mr. Arbery wouldn't be dead. So we've got our old-fashioned but for, and that's what we're talking about here. Played a substantial and necessary part in causing the death. But for these actions, Mr. Arbery would still be alive. So when we look at, specifically, I'll take them in the order Mr. Hogue went, we're talking about count 5 felony murder and count 9, which is criminal attempt to commit false imprisonment on Burford. The indictment reads, in violation of the personal liberty of Ahmaud Arbery, did unlawfully chase Ahmaud Arbery through the public roadways of Satilla Shores neighborhood in pickup trucks, did attempt to confine and detain Ahmaud Arbery without legal authority on Burford using a Ford F-150 and a Chevy Silverado. So they attempted to confine him, but he managed to get away. They basically both used the pickup trucks. So we've got Mr. Bryan, principal, actively attempting to detain Mr. Arbery. We've got Travis McMichael in his pickup truck. Circumstantial evidence that he is actively attempting to detain Mr. Arbery, because why? Mr. Arbery turns around from the white pickup truck and runs back the other way. And this is after Greg McMichael is in the truck yelling, cut him off, cut him off, cut him off. So at this point, we've got all 3 men acting in concert to attempt to confine him there. Well, how do they do that? They go ahead and do that by aggravated assault with their pickup trucks, by placing him in reasonable apprehension of receiving serious bodily injury. Well, what does that mean? It means their actions, what were they doing? They're using these pickup trucks with the aggravated assault to confine and detain him. So the state has proven that they use these pickup trucks in a manner that would reasonably put someone in fear and apprehension of receiving bodily injury. What does that mean? They scared him. They scared him with the aggravated assaults. And that was part of the false imprisonment. We're going to scare you into stopping by using these pickup trucks to cut you off and run you into a ditch. They were doing it in concert with each other. I want to be real clear. The defense is attempting to conflate conspiracy, which is we pre-planned this thing, or conspiracy, which is wink and a nod. No, we're talking party to a crime. Okay? Conspiracy is a completely different charge. We are going to ask for it, but in this case, this is a party to a crime, which is intentionally doing these things to aid and abet. Mr. Bryan's in his driveway. He intentionally gets in his pickup truck to aid and abet the McMichaels, who he sees are actively trying to detain Mr. Arbery in violation of his personal liberty, falsely imprison him. He's actually in the top of his driveway looking down. The white pickup truck, he can see it. Mr. Arbery's running back toward him. They can see that Mr. Bryan is now pulled out. They make a decision based on this to go around homes, but for their decisions on Burford, but for their attempt to falsely imprison Mr. Arbery would not be dead. The false imprisonment on Burford substantially contributed to his death because it's what made him stop running. They didn't allow him to run up Burford and on to Zellwood, which would have then led right out of the neighborhood. Because if he'd gone up Burford, gone over Zellwood, he'd eventually gotten to Satilla Drive and could have gotten away and he wouldn't be dead. So this substantially contributed. But for these actions on Burford, none of the rest of it would have happened. So what did happen? Well, he then has to run back. Mr. Bryan, of course, once again cuts him off. He then immediately turns up homes to get away from Mr. Bryan in his pickup truck, which has now cut him off from his route going out Satilla Drive. But for those aggravated assaults which were used to falsely imprison him there on Burford, he would not have been going up homes, which then led him to encounter the white pickup truck coming down homes. We have him trapped like a rat. He ends up with no place to go, and he ends up exhausted, fight or flight, turns around the corner, and is shot. So all of this led up immediately to the death, and therefore it's a question for the jury. And in this case, the standard, as the court knows, is we view all of the evidence presented at trial in the light most favorable to the verdicts, and ask whether any rational trier of fact could have found that the defendant was guilty beyond a reasonable doubt. That's for the jury to decide. They're going to go ahead and look at this, and but for those actions on Burford, would he have ever been trapped like a rat between two pickup trucks on Holmes Drive? No, he wouldn't have been. So it materially and substantially contributed to his death by getting us to that point. And this is all one continuous event. This is 5 minutes of this going on. So it's not these separate little vignettes. This is continuous. They're going around. Mr. Bryan's driving him this way. They're going this way to go ahead and capture him and trap him on Holmes. And that was their intention, all because they wanted to talk to him. So we've got that. We ask that you deny the motion for directed verdict on counts 5 and counts 9. Then we've got I believe Mr. Hogue then did 3 and 7, which is our aggravated assault with the pickup trucks. Count 7, did make an assault upon the person of Ahmaud Arbery with a Ford F-150 pickup truck and a Chevy Silverado pickup truck. Objects, devices, and instruments, when used offensively against a person, are likely to result in serious bodily injury. 2.20.21, aggravated assault with a deadly or offensive weapon. Assault another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. And then, of course, an offensive weapon is any object that is likely or actually does cause death or serious bodily injury if used against someone. It's not in dispute that a 5,000-pound lethal weapon like a pickup truck can cause serious bodily injury to someone. The question is, were their acts, what they did, such that it would put a reasonable person in reasonable apprehension? In other words, did what they do cause fear? Yes. Now, we don't have Mr. Arbery to go ahead and take the stand and go, yes, I was afraid. He's dead. But the jury's allowed to go ahead and look at this and go, okay, let's look at their acts. Did they commit an act that placed Mr. Arbery in reasonable apprehension or fear of immediately receiving a violent injury? Yes, both direct and circumstantially they did, with aggravated assault with these pickup trucks. So once again now, felony murder, we're back to our but-for situation. So but for them attempting to strike him, cut him off, run him into a ditch, impede him, run up next to him. I mean, Mr. Arbery's just running down the road, and they pull up with a pickup truck right next to him and start yelling at him. Stop, stop, we want to talk to you. So at that point, just that alone, is that an action that would put somebody in fear? I mean, total strangers have pulled up next to you. You don't have a car. You're running. That's a question for the jury. Now, the aggravated assault with the pickup trucks, the state feels not a problem, proving that beyond a reasonable doubt. Did it play a substantial and necessary part in causing his death? Yes. Now, as Mr. Hogue pointed out, at the time of his death, the white pickup truck, which had already been used offensively against him, trying to falsely imprison him on Burford, and then once again coming down Holmes Drive, goes ahead and passes Mr. Arbery. We know this, okay? Because what do we have? We've got Mr. Bryan on the video. Mr. Arbery suddenly turns around. Now, whether you can see the white pickup truck or not, he suddenly turns around and runs back down. Mr. Bryan goes up. Mr. Bryan turns around. He comes back up. And the video's there. And what do we have? That truck is parked at the end of the road. Based on their statements, Agent Dialis testified they went up Zellwood and came down Holmes. That means they passed Mr. Arbery once again with that white pickup truck. He is pinned between the two of them, the black pickup truck and the white pickup truck, and then the white pickup truck passes him when he turns around and then parks in front of him. That is the aggravated assault. But for them using those pickup trucks in that manner, he would not be dead, because he's trying to run up Holmes and the white pickup truck's coming. He runs back down. Now Mr. Bryan's at the top of Holmes and the white pickup truck's at the bottom of Holmes. He is pinned. Greg McMichael said he was trapped like a rat, and he knew it. That was what Greg McMichael said. So when he's trapped like a rat between these two pickup trucks, did that substantially, materially, did that play a substantial and necessary part in causing the death? It was absolutely necessary, because they had him between these two pickup trucks. They'd caused him fear. Actions put him in reasonable apprehension of receiving serious bodily injury with the pickup trucks, and at this point in time, as a party to the crime, they've stopped their pickup truck. But Mr. Bryan hasn't stopped his pickup truck. Not at all. He is coming up behind Mr. Arbery. He is revving that engine. You can hear it on the video. And as a party to the crime, they can see that pickup truck coming. Seeing that pickup truck coming didn't stop Travis McMichael from pulling up that shotgun and pointing it at Mr. Arbery. And then he tracks him around and then shoots Mr. Arbery. The fact that Mr. Bryan and the McMichaels, as a party to the crime of the use of that pickup truck at that moment, it becomes felony murder for the aggravated assault with the pickup truck. The state will argue, of course, that the use of the pickup truck the entire time, but for that, he wouldn't have been where he was. But for all the actions that the McMichaels took in their white pickup truck, Mr. Arbery would not have been where he was and would not have been trying to escape this particular attack and assault. So we ask that you deny the directed verdict on counts 3 and count 7. Then we have, of course, count 4 and 8. This was the fourth one that Mr. Hogue mentioned. I'm going to pause for some water, Judge. Count 4 of the indictment, count 8 of the indictment. In violation of the personal liberty of Ahmaud Arbery, did unlawfully confine and detain Ahmaud Arbery without legal authority, to wit. Said accused did chase Ahmaud Arbery with a Ford F-150 pickup truck and a Chevy Silverado pickup truck through the public roadways of the Satilla Shores neighborhood, and did confine and detain Ahmaud Arbery on Holmes Drive using said pickup trucks. Greg McMichael's statement: he was trapped like a rat. He was trapped between the two pickup trucks. State has gone ahead and proven count 8. So how did that materially, substantially, and necessarily cause the death of Ahmaud Arbery? Because he's trapped between these two pickup trucks. He's right there in Holmes. He's running toward a man pointing a shotgun at him, and that man is relentless. He doesn't give up. He doesn't stay on the side of his pickup truck. So here we've got the ultimate confinement. And Judge, the ultimate confinement is death. Here he was ultimately falsely imprisoned because he was shot right there. Ultimate false imprisonment. But what they actually did is, when they put Mr. Arbery in reasonable apprehension, fear of receiving bodily injury with the pickup trucks, they had him trapped like a rat. Once again, fight or flight. All he did was flee from these people. All he did was try and get away. But according to Greg McMichael, he was trapped. Greg McMichael is standing in the back of that pickup truck yelling at him, "Stop, goddammit, stop." He previously told him he was going to kill him. He was going to blow his effing head off. So at this point in time, if he had not been falsely imprisoned and trapped between these pickup trucks, he would not have been shot. The killing is the ultimate confinement. And I get that the defense is saying, well, he had options and he should have run this way and he could have run that way. Well, they're parked right in front of that driveway. They didn't actually go up to the stop sign at the end. They parked in that driveway. He was going around this side. There's a driveway to a house right there. He comes around the very front of it. They want to make it seem as if he's the one at fault for not continuing to run. He's the one at fault because they made him afraid. He's the one at fault because he didn't want to get, I don't know, it would be speculation, but nobody wants to get shot in the back with a shotgun. He's already been told they're going to kill him if he doesn't stop. So at this point in time, falsely imprisoning him there and keeping and confining him there substantially and necessarily caused his death. Blaming him for not continuing to run on, or him utilizing his options to defend himself, is not really, how do I put this? What Mr. Arbery chose to do in his intent is not relevant. The acts of the defendant are that's what's relevant here. And trapping him like a rat between two pickup trucks, one of which he was actively running away from as it pursued him forcing him towards the white pickup truck and Travis McMichael and his shotgun, that was actual false imprisonment, because he never ever got away from them on Holmes Drive. He was killed. So it substantially contributed to his death. When we look at counts, so we ask you to deny the directed verdict as to 4 and 8. When we look at counts 2 and 6, once again, 2 being felony murder based on the aggravated assault with a shotgun. Count 6 is did make an assault upon the person of Ahmaud Arbery with a firearm, a deadly weapon, to wit, a 12-gauge shotgun. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. All right, so, Judge, I hear what Mr. Hogue's saying, that pointing the shotgun at him where it's up against here is an aggravated assault, and it is. And if he had never fired at him, if he'd just done that, he'd be guilty of aggravated assault. However, as you know, our Supreme Court has recently told the state, you can't go charging different moments in time in a continuous action. They've told us that. They said you can't do it. It's all one aggravated assault. There has to be an intervening factor, meaning, I think the one case that we're talking about is, it was an aggravated assault on a woman, boyfriend, girlfriend, and he went ahead and slashed her face. So we've got aggravated battery. Then there was an intervening time period where she got away from him. Then he went up and I think he stabbed her in the neck. Those were 2 separate things solely because of the intervening time factor. But the courts have said, meaning our Supreme Court has held, it's all one thing. But in this particular case, the state's not contending that it's 2 separate aggravated assaults. It's one aggravated assault when he pulled the trigger and shot him. So I just want everybody to be really, really clear. The state is arguing the state must prove that the defendant attempted to cause a violent injury to the person. And he attempted to cause a violent injury to the person when he shot him point blank in the torso with that shotgun. They are all parties to the crime of this. Because Greg McMichael's already threatened to shoot him with a, stop or blow your effing head off. Mr. Bryan sees that shotgun, sees it come out, sees exactly what's going on. We might not see it on the camera, but he's driving the truck and he's driving Mr. Arbery right towards that man with the shotgun, helping him to go ahead and commit this crime. So at this point in time, we've got the aggravated assault. Here, Travis McMichael actually pulled the trigger. Greg McMichael helped and encouraged Travis McMichael. Travis McMichael grabbed his shotgun in his driveway decision at his house, chose to bring that shotgun along, and Greg McMichael knew it. There's absolutely no evidence that Greg McMichael told him not to bring it along. Don't bring that shotgun. Nothing like that. Greg McMichael got into the truck with his son knowing he had that shotgun. This is circumstantial evidence. Greg McMichael's in the truck with Travis McMichael the entire time that he has this shotgun, both in the pickup truck, and then when Greg McMichael gets in the back of the pickup truck, Greg McMichael's yelling at Ahmaud, stop, stop. Greg McMichael's giving Travis McMichael, directions, cut him off, cut him off, cut him off. In the moment that Travis McMichael is outside, Greg McMichael can see he's got the shotgun. Stop, goddammit, stop, is what he's saying to Mr. Arbery. That is helping, intentionally aiding and abetting, knowing full well that the shotgun is being pointed at Mr. Arbery. And it's kind of encouraging. It's tacitly basically authorizing this and encouraging him, because he's not telling his son to stop doing that. You don't hear, put the shotgun down. You don't hear, what the heck are you doing? Don't do that. You hear, stop, goddammit. Travis McMichael is driving. And the one thing that's kind of important here, Judge, is that Mr. Hogue, when it came to Greg McMichael's statement, actually asked Parker Marcy a question. And it was unobjected to by Greg McMichael's counsel, but I know the court noticed it, I noticed it. It was my intention, and I know it was my son's, to arrest him or at least to get him identified. There was no objection from Travis McMichael. So at this point, what's before the court, unobjected to by Travis McMichael's counsel, is what their intentions were here. And, of course, they're going to argue, well, it was to arrest him or at least get him identified. So if this is Travis McMichael's intention, it was Greg McMichael's intention, and that's what they were doing, and they were doing it at the point of a shotgun. With regard to Mr. Bryan, Mr. Bryan never called 911. Mr. Bryan continues forward recording despite the shotgun coming out. Mr. Bryan says absolutely nothing on the recording. He doesn't go, oh my God, there's a shotgun. Oh my God, what's he doing? He doesn't, like I said, swerve out of the way and into a ditch. He doesn't put it in reverse and back up so he's out of the line of fire. He pulls forward and accelerates despite the shotgun coming out. Doesn't slam on the brakes, does not protest, does not yell, doesn't honk, doesn't do anything but keep driving forward, driving Ahmaud Arbery forward. We get to this location by Mr. Bryan pursuing Mr. Arbery, because as we saw in the video, Mr. Arbery had actually run away from the white truck again. Mr. Arbery runs, we see that. He's going down homes towards Satilla. Mr. Bryan goes up and he turns around. At this point, we actually see Mr. Arbery back at the blue mailbox, having turned around, being forced to run back toward the white pickup truck. Therefore, he helped by chasing Mr. Arbery toward the white F-150 pickup truck, despite Arbery's obvious attempts to get away from the white pickup truck. But he encounters Mr. Bryan in the Silverado, so he has to run back toward the white pickup truck. Once again, a party to the crime in making this happen. And we all know that even if your finger is not on the trigger, you can still be held responsible. I mean, we all know that the getaway driver who doesn't go into the convenience store is just as guilty as the guy who goes into the convenience store and pulls the trigger because he's there to help make it happen. Help make it happen. And here we have Travis McMichael actually pulling the trigger, Greg McMichael helping to make it happen, and William Bryan helping to make this happen. Because without their help and assistance, without Greg McMichael, especially his encouragement, Travis McMichael would not necessarily have been able to complete this had not Mr. Bryan driven Mr. Arbery toward the parked white pickup truck. If Mr. Bryan had actually kept going and up around Zellwood, or had left, Mr. Arbery would have been able to keep running up Holmes and maybe get to Zellwood and Satilla. Thus, Mr. Bryan confining him there contributed substantially and materially to the felony murder and the aggravated assault with a deadly weapon. So we ask that you go ahead and also deny the directed verdict for counts 2 and 6 of the indictment as to Greg McMichael and Travis McMichael. Did I miss anything? Okay. Thank you, Your Honor.
Any final word from the McMichael defendants on their motion?
Yes, just very briefly, Your Honor. Can you hear me from here? Citing the language in State v. Jackson, 287 Georgia 646, 2010, Georgia Supreme Court case. Justice Namias. We have also said that proximate cause is the standard for homicide cases in general, and then he cites cases and is quoting from Wilson v. State. We set out the following test for determining causation in homicide cases. Where one inflicts an unlawful injury, such injury is to be accounted as the efficient proximate cause of death whenever it shall be made to appear either that, and there are 3 subparts. 1, the injury itself constituted the sole proximate cause of the death, or 2, the injury directly and materially contributed to the happening of a subsequent accruing immediate cause of the death, or 3, the injury materially accelerated the death, although proximately occasioned by a pre-existing cause. That one doesn't apply here. So the proximate cause issue in counts 2, 3, 4, and 5 is at the heart of our motion, and I think the state's failed to make that connection between the underlying felonies that are named in counts 6, 7, 8, and 9 and the accruing death based on this test from this case. And of course that's a completely different problem than the Malice Murder, and I won't say anything more about that. So that's our response to the state's, our reply to the state's response.
I'm sorry, Judge, but may I distinguish that case, having just heard it, not knowing it in advance? That case was a co-defendant felony murder case, meaning a whole bunch of people went in to commit a crime, and the victim fought back, and it ended up with one of the co-defendants murdered. So they're talking about proximate cause for the armed robbers, one armed robber being responsible for the death of his co-armed robber. That's what that case is about, not this sort of situation.
Well, I will just add that next paragraph says, consistent with this general rule, which I just read, we have held in many cases and for many decades that the proximate causation is the standard for murder cases prosecuted under the murder statute codified at OCGA 1651. The particular facts of this case are immaterial. It's the rule that I'm talking about.
Mr. Goff, on behalf of Mr. Bryan, any directed verdict?
Good morning, Your Honor. Your Honor, first thing I'll do is I'll formally adopt the very cogent arguments made by co-counsel in this case. And without tracking through those, but for Beth Brigmo giving birth to Roddy Bryan, God rest her soul, many years ago, but for that, Roddy Bryan wouldn't have been out there that day in his pickup truck. When we use this but-for causation, that there's a lot of baggage that comes along with that, and with all due respect to Ms. Dunikoski, it feels like they are stretching that term beyond recognition. The legal standard is proximate cause, and we'll come back to that in a moment, but when you look at it as proximate cause and not simply reducing it to two words, but for, I think the court understands why the defendants are here making these motions. Your Honor, with respect to count one, malice murder, I'm really at a loss here to understand, but it was the state that decided to present what we sometimes call a kitchen sink indictment to the grand jury, where every defendant is charged in every possible way with every possible crime in this case. That was a decision the state made, and I certainly appreciate the challenge to the court in trying to assess these issues. As I look at the malice murder charge, there is no contention that Roddy Bryan shot anybody. There's no contention that Roddy Bryan tried to shoot anybody. There's no contention here that Mr. Bryan is acting as a principal. This is, if I misunderstood Ms. Dunikoski, I'm sure she'll correct me. The entire theory here is aiding and abetting, third section of that statute. And where is it that Mr. Bryan is intentionally aiding and abetting the shooting? Because he's not. Now, maybe some decision came out of the Supreme Court last week or last month that I'm unaware of. But when I went back through Kurtz last night, or it used to be called Kurtz, Offenses and Defenses in Georgia, and the section on parties to a crime, I know the court knows the treatise that I'm talking about. They list like 30 different ways that you can be a party to a crime, that you can be aiding and abetting in a murder case. But none of those are like the case before this court. Which is why, although Ms. Dunikoski has cited this court well over 100 cases in oral argument, probably thousands of cases, and all the pleadings that have been filed and motions and responses going back and forth, Ms. Dunikoski cannot cite to you a single Georgia case that is remotely comparable to the one that we have before the court. This isn't the case where Mr. Bryan is driving down the street in his pickup truck and Travis McMichael is standing in the back of it shooting at Mr. Arbery. This isn't that case. There is no case, and she can cite no case, remotely close to this one. The closest cases that I've been able to find, and of course they're referenced in there, in what I call the distraction aiding and abetting cases, in which one person intentionally distracts another person while someone else behind them either takes a knife and stabs them with it or shoots them. I call them distraction cases, where you're aiding and abetting by distracting. There is no evidence and no suggestion here that Mr. Bryan's conduct has somehow distracted Mr. Arbery. He's well aware of the pickup truck in front of him from the video. He's well aware from the video that they are both armed. So, and Mr. Arbery is not shot with his back turned. That might pose a different and a closer question for the court. But in this case, unless Ms. Dunikoski can cite some Georgia case suggesting this, which I still don't understand, theory of aiding and abetting the shooting of Mr. Arbery, there simply is no malice murder case here. And, you know, co-counsel points out some pretty good cases on what the mens rea is required here. Where is any of that for Mr. Bryan? There's no malignant heart in this case. There's nothing from which that could be presumed. And, you know, that takes us back to the whole concept of a citizen arrest. If I understand the state's theory here, the state contends that the McMichaels, and I believe they're contending that Mr. Bryan was assisting them or aiding them in attempting to make a citizen's arrest, which in the opinion of the state was not authorized under Georgia law. And that may be true, Your Honor. But the fact that Mr. Bryan aided and abetted a citizen arrest, if he did that, doesn't establish malice in this case. It doesn't establish an intent to aid and abet an intent for a shooting. You know, and Your Honor, I would urge the court to ponder the larger implications of the legal ruling that the state is requesting here. Because in this one case, it might serve the interests of the state. But in the larger question, if 10 police officers respond to a call, 10 police officers pull their cars up around a scene, and they're there, maybe they're still moving, Your Honor, and inexplicably, a police officer discharges his weapon and shoots the person that they're after in the head. Maybe they had probable cause, maybe they didn't. But are we going to try every police officer who's present at the scene of an attempted arrest for malice murder because somehow in aiding and abetting an attempt at an arrest, lawful or unlawful, that translates into aiding and abetting the shooting that follows? That can't be the law, Your Honor. And we shouldn't be creating special rules of law. There are already enough of those. We shouldn't be creating any more special rules of law for one case, because we know the reality is that these things have unintended consequences and they take on a life of their own. We don't need to start down this theory that anybody who's attempting to arrest someone, which after the last legislative session is pretty much limited to police officers, that anytime police officers are attempting to arrest somebody, particularly if they're attempting to do so unlawfully, that they're aiding and abetting the arrest, lawful or unlawful, is aiding and abetting a shooting or other unlawful use of force that follows. There is no malice murder case as to Mr. Bryan. There is no authority for this case. Your Honor, the state wants to talk about but for. I want to talk about intervening factors. And before I do that, Your Honor, I would, maybe it's just me, maybe I'm just not smart enough to keep up this Dunikoski here, but the way Ms. Dunikoski is presenting this malice murder argument to the court is, in essence, collapsing malice murder into felony murder. What distinction is left here between malice murder and felony murder when Ms. Dunikoski makes these arguments? Because it's winding up being the same thing. Well, you know, he intended to shoot, therefore he intended to kill. Or he intended to falsely imprison, he must intend to shoot. How do we distinguish at the end of the day with the arguments made by the state between malice murder and felony murder? Your Honor, this is a case, and this feeds into the severance issue. And with all due respect to Ms. Dunikoski, I would humbly suggest to the court that if Ms. Dunikoski continues to proceed along this line with malice murder, and we go into the defense case here, we are going to have, at some point, antagonistic defenses that cannot be overlooked. The state, as I understand it, has not submitted a charge on manslaughter. My understanding that learned co-counsel from the McMichael defendants has not submitted a jury charge on manslaughter. And part of that, I think, well, there's different strategic reasons why people do things, but my point to Your Honor is, in terms of proximate cause, do we not have not one, but two intervening factors here, factors that are not reasonably foreseeable to Roddy Bryan. Maybe logically foreseeable and something that's conceptually possible, but not reasonably foreseeable in the sense that the law would imply. You have in the video, and unless I missed it, this part of the video the state contends is undisputed, uncontradicted. In the video, at the last minute, you see Mr. Arbery, instead of turning right towards the exit of Satilla Shores, he turns to the left. Now, it's not for me to judge or question why Mr. Arbery does the things he does, but when he turns left instead of right, regardless of his justifications or his reasons for doing so, that is an intervening cause, an intervening circumstance, I submit, under Georgia law. And at that point, it's not foreseeable to Mr. Bryan. It's not foreseeable that just like on the street with the police officers, suicide by cop is not reasonably foreseeable, nor is suicide by citizen's arrest. When Mr. Arbery turns towards Mr. McMichael, that is an intervening circumstance that breaks any causative chain here with respect to the shooting and death itself. Likewise, and I'm certainly not taking sides in this. It'll be for the jury and the court to determine the guilt or innocence of the McMichael defendants. But at the same time, you have a second intervening factor. The first intervening factor is Mr. Arbery pivoting to the left instead of heading for the exit. The second intervening factor is Travis McMichael discharging his weapon. And I'm not questioning why Mr. Arbery is doing what he's doing. I'm not questioning why Travis McMichael is doing what he's doing. But what I'm saying is you have a second intervening factor, which is the choice of Travis McMichael to discharge his weapon. It doesn't really matter for purposes of evaluating count one malice murder if the court can see that whoever's in the right here, whoever's in the wrong, whichever party is using excessive force, maybe both parties are using excessive force, maybe there's some kind of mutual combat theory to be had out there. But from Mr. Bryan's perspective, in terms of proximate cause, in terms of what's reasonably foreseeable to him, none of these things are reasonably foreseeable. And I think the court understands the consequences if the court were to go down any other road. And if we're going to persist with this issue, we're going to wind up in a severance posture. It may be premature. We haven't heard whether any of the other defendants have testified yet. But I would submit the easiest way to resolve the severance issue is to grant the motion for directed verdict for Mr. Bryan as to malice murder. Moving on to count 2, felony murder, which is tied to count 6, aggravated assault to a shotgun. Again, the arguments come down very much the same way, because the state's position on malice murder is essentially, although not in so many words, collapsing into felony murder. Where is the intent on the part of Mr. Bryan to facilitate an aggravated assault with a shotgun? Again, it's one thing to say, if the state contends that's what the evidence shows, that Mr. Bryan is attempting to assist in a citizen's arrest, aiding and abetting a citizen's arrest. But there's nothing reasonably foreseeable about killing someone in a citizen arrest. Just as on the street, there's nothing reasonably foreseeable to police officers when a fellow officer, without cause, discharges a weapon, in these days maybe even a taser, and kills somebody. Again, there is no proximate cause, and there is no mens rea, there is no aiding and abetting the shooting. Now, Ms. Dunikoski wants to make a big deal of the fact that the gun is visible, that Mr. Bryan's truck is still moving, although obviously at a slow rate of speed, and therefore because he doesn't run in a ditch or he doesn't back up, that he somehow is now joining in the shooting. But again, I understand the state's position is pretty clear, almost uncontradicted, that this is a purported attempted citizen arrest. Again, in the context of a citizen arrest, is the fact that Mr. Bryan is maneuvering his truck, and positioning his cell phone to follow Mr. Arbery and document what Mr. Arbery is doing. How does that circumstance, whether he's traveling at 2 miles an hour, 4 miles an hour, or 6, how does that establish his aiding and abetting the shooting itself? Because Mr. Bryan only has knowledge of the existence of the weapon, as we see on the video, at the very last moment. And still, at that time, from Mr. Bryan's perspective, even if he's attempting to aid and abet a citizen arrest, That's not the same thing as aiding and abetting a murder. I mean, would it be any, it's the same thing, Your Honor, whether Travis McMichael is shooting him or not, or whether he's pulling out a club and beating him on the side of the road with a billy club like a police officer would do. Again, how is Mr. Bryan's assisting, if that's what it is, in a citizen arrest, showing that he's attempting to aid and abet the shooting, aiding and abet an unlawful, excessive use of force in the making of an arrest? That's just not there. That's just not Georgia law. And again, the state says the jury should consider the fact that they had their guns drawn. Okay, well, how is Mr. Bryan, again, to know that they have any intent in drawing a weapon, whether it's in the down position, the up position? I'm not a use of force expert, but whatever position. Again, how is that telling Mr. Bryan that they intend to use excessive force, that they intend to kill him, that they're not trying? Maybe that's the state's theory, that they weren't really trying to make an unlawful arrest. They were just looking for an excuse to kill him. Or they were just waiting for the opportunity, notwithstanding the fact that they've had lots of opportunities to shoot this gentleman over 5 minutes. He's clearly, in terms of proximate cause, when you look at the video, you see Mr. Arbery. He's well within range. He's well within shotgun range. He's also well within range of Gregory McMichael's handgun at the time that Mr. Bryan is pulling up. From Mr. Bryan's perspective, he didn't have any reason to think they were trying or intended to hurt these people. They had ample opportunity to do that long before he got there, long before he pulled up. Again, I'm asking the court to grant a directed verdict on count 2, felony murder based on the underlying count 6, aggravated assault with a shotgun. Count 3, felony murder, aggravated assault with a pickup truck. Your Honor, although the statute defines the grounds for a directed verdict, I believe Ms. Dunikoski has acknowledged that it's not that simple, that the standard essentially goes back to Jackson v. Virginia. It's not just whether there's quote-unquote any evidence to submit something to a jury. There has to be sufficient evidence from which a rational juror could find guilt beyond a reasonable doubt. There is a severe lack of evidence in this case. There's no evidence that Mr. Bryan intended to do so. What they're doing is they're basing that on words, and I'm going to incorporate here for purposes of the motion for directed verdict the arguments made in connection with the special demurrer in this case. And of course, those have also already been addressed to some extent by counsel for the McMichaels. Now, there's no witness. There is no witness to what Mr. Bryan did. There's no video of an aggravated assault. It's all contradicted by the physical evidence in this case. And I don't have the citation in front of me, but with respect to aggravated assault with a motor vehicle, I think the case law, there is a case specifically out there that says speculation as to aggravated assault is inappropriate. And there are some times when there's insufficient evidence and where the jury is basically being asked to speculate as to what happened. And this is that case, Your Honor. And with terms of felony murder, again, you get back to the same issue. Assuming for the moment that Mr. Bryan was committing an aggravated assault with a pickup truck down on Burford, how does that establish, how is that the proximate cause of a felony murder that takes place down on Holmes Street later? And for the jury to be able to return a verdict, because of the way this indictment is phrased, the jury can return a verdict of guilty without specifying where it takes place. How do we know that the jurors, certainly all 12 of them, have made a decision as to that? Because without that, how can they make a determination as to proximate cause? This is a huge problem. And I'm going to get back to count 7 in a moment. But in terms of felony murder, there's just no proximate cause here. It's not reasonably foreseeable. And it's a huge stretch to say that what Mr. Bryan is doing out there in his truck is causing the death. In fact, I think the McMichael lawyers have already pointed out that their truck is stopped. It's not even moving. And Ms. Dunikoski talks about revving the engine, but the video speaks for itself. Certainly Mr. Arbery is not assaulting at this time. Your Honor, there's no proximate cause. There's insufficient connection to the death. I'm going to turn to count 4, felony murder, which is based on false imprisonment. Your Honor, I do believe that there was a special demurrer filed in this case previously about false imprisonment, and if I recall, the court cited a case, and I don't have it in front of me, about you can imprison with a pickup truck. My recollection of that case was a case where not just where someone was being chased, but where they actually were struck and went over the hood, and then the person in the car got out or did a stabbing. That's certainly factually distinguishable. But again, what is it if the false at the time of the shooting there is no false imprisonment, Your Honor? At the time of the shooting, Mr. Arbery, to borrow a football phrase, has broken containment. He is past both trucks at that point and has a clear line to the exit to the neighborhood. So I don't understand how you could have proximate cause between a false imprisonment, if that's what it is, and the shooting itself. Because there isn't. I'd also contend, notwithstanding Georgia law to the contrary, that false imprisonment is not the kind of felony that will support a felony murder charge. There are other jurisdictions that disagree with Georgia, and under their laws, they do not view false imprisonment as a violent offense. That would be a felony you could base a false imprisonment on. I certainly want to preserve that argument because it's just, I guess the best way to phrase it in terms of Georgia law is false imprisonment really is more like a status offense than it is a violent offense. And in that respect, it should not be the underlying felony for a felony murder charge. We still have issues with the mens rea. We still contend that the false imprisonment is unsupported factually. But again, in terms of foreseeable, how is the shooting, Your Honor, reasonably foreseeable to Mr. Bryan, assuming that there is a false imprisonment? How is the shooting itself? It's one thing to say that Mr. Bryan aided and abetted a false imprisonment. That's not the same thing as saying he aided and abetted a shooting. And that, again, goes back over ground I think I've already covered, and I won't do that to the court again. Count 5, felony murder. Again, we contend that criminal attempt to commit felony murder is not the kind of offense upon which a felony murder charge can be predicated. We would suggest to the court that is even a step further removed from false imprisonment itself, and that furthermore that the attempted false imprisonment is not the proximate cause, again, of the shooting or death of Mr. Arbery. There are real problems there with the causal link. Count 6, aggravated assault with a shotgun. Again, there is no aiding and abetting for Mr. Bryan. Aiding and abetting a citizen arrest, even if unlawful, is not the same thing as aiding and abetting a shooting. And I won't go back down that ground any further. Count 7, aggravated assault with the trucks. Co-counsel has already spent a good bit of time addressing this. I've addressed it in the special demurrer. It's troubling to me that the state comes in here when 3 police officers, Your Honor, 3 seasoned police officers, well, 2 well-seasoned, 1 we could argue about, all interview Mr. Bryan, and that's the basis of this count, is Mr. Bryan's statements himself. There's no other evidence other than that in this case. And all 3 of these officers interviewed Mr. Bryan, or talked to Mr. Bryan at length. All 3 summarized those interviews. None of them refer to Mr. Bryan's conduct as an aggravated assault. None of them do that because it's not there. The jury, Your Honor, is required to get to the truth of the matter. It's not just the words that Mr. Bryan uses, which anybody's words can be twisted out of context. It's the context in which they're given. It's the meaning that's meant to be conveyed. And it's clear from the testimony of the state's own witnesses that meaning is not there. There is no aggravated assault with Mr. Bryan. And I'm jumping back and forth here, I guess, make sure where I am. Your Honor, the evidence is, in terms of the speed, for example, that while the state refers to Mr. Bryan as chasing, that the evidence is on the video is at 2 miles an hour. Your Honor, with respect to count 8, the false imprisonment, the indictment alleges, and the state is stuck with the language in the indictment, that that the confinement and detainment occurs on Holmes Drive. But the evidence that the state is relying on is coming from Burford, and he can't be convicted at this point of that. And how the court would charge the jury, I have no idea. Your Honor, on count 8, the false imprisonment, I talked earlier about the breaking containment. There is some Georgia case law out there, and for example, I guess this is the best analogy I can come up with here. In a bank robbery, when an individual committing a bank robbery pulls out a gun and tells everybody to get down on the ground, under Georgia law, that is a false imprisonment because they get on the ground. But this case isn't the case where they get on the ground. Mr. Arbery never submits to being arrested. And in this case, this is what the state is pursuing here is the equivalent to someone in a store saying, everybody get down on the ground, and the person just continuing to run right out the door. That's what we have here, and that is not a false imprisonment under Georgia law. And again, if Ms. Dunikoski has a case citation for this court to any Georgia case that is remotely factually close to this one, I'm sure she'll present it, but I can't find it. Your Honor, attempted false imprisonment, that's count 9. We contend that the evidence is simply insufficient to submit that matter to the jury. Moreover, we think the evidence that was presented during the state's case in chief shows affirmatively abandonment. That Mr. Bryan has abandoned this chase, as they call it, and the video itself, I think, demonstrates that at the time of the shooting, Mr. Bryan is simply a witness to the shooting itself and to those events. And under those circumstances, we believe that he is entitled to have an acquittal as to count 9 and all the other counts in this indictment. We would ask that a directed verdict be granted on all counts and that Mr. Bryan be released forthwith.
Before the state responds, could we break briefly for restroom?
Yeah, it's going to take a 10-minute recess. So let's go ahead and take 10 minutes. We'll reconvene at 10 of. Thank you.